Victims of domestic violence where children are part of the household face a seemingly terrible dilemma: endure the domestic violence in silence or seek help, and risk Child Protective Services involvement, potentially losing your children forever. Why is this such a difficult choice? It comes down to 3 words: failure to protect. This term refers to the failure to protect your minor children from harm or possible harm. In cases of domestic violence, CPS is concerned about physical or psychological abuse, or the mere risk of potential physical abuse, psychological abuse, and trauma to the children, even if they weren't directly involved or did not witness the confrontation, but were present somewhere in the home. When domestic violence occurs, the most common recommendation is to call 911. However, law enforcement are mandated reporters in every state. This means that if you have children, reaching out to law enforcement for help can be risky, as law enforcement is required by law to report it to CPS. Orders of protection often only protect the adult victim, not the children, which CPS doesn't like. Since they see a risk to the children, they will get their own order that protects the victim, as CPS defines him or her and the children. This can lead to prolonged monitoring by CPS and supervised visitation controlled by the courts. When CPS investigates a report that includes allegations of domestic violence, they look at both physical and psychological trauma. The children don't have to be directly involved. Their mere presence in the home during such conflict creates high potential for psychological trauma. If CPS alleges domestic violence, it's advisable for the alleged perpetrator to leave the home until CPS involvement is over. The alleged victim should get an order of protection which protects both them and the children. Even if the victim already has an order protecting themselves that doesn't include the children, and set up supervised visitation on their own. This will prevent CPS from doing so themselves, keeping you in control. This will prevent CPS from having a reason to get a redundant order. After CPS is no longer involved, the victim as defined by CPS can either let the order lapse, violate the order, as courts rarely, if ever, prosecute victims for violating an order of protection. At this point, the family can become whole once again. The following states allow exoneration from failure to protect allegations against domestic violence victims in CPS cases unconditionally at the discretion of CPS: Iowa, New Hampshire, Oregon, and Wisconsin. The following states allow the same under specific conditions at the discretion of CPS determined by each state: Kentucky, Maine, Michigan, Montana, Nevada, New Jersey, Texas, Washington, and West Virginia. If you do not see your state listed here, it does not allow exoneration from allegations of failure to protect for domestic violence victims in any CPS case. Washington, D.C. also does not allow exoneration from failure to protect allegations against domestic violence victims in CPS cases. Don't wait until your family is already in trouble. Don't become one of those parents who look back and regret saying, "I wish I knew then what I know now." Visit cpsprotect.com or call toll-free at 844-633-KIDS. CPS Protect Consulting Services, saving children, preserving families.